Hello, I'm Jaspreet on this side, and we are doing revision of Companies Act 2013 using Saransh by ICAI. So far we have created uh, 14 videos, and this is the 15th video. In last video, we covered internal audit, appointment of statutory auditor, casual vacancy of auditor, reappointment of retiring auditor. So in this video, we are proceeding with term of auditor. Section 139(2). So section 139 subsection 2, term of auditor. So listed companies and prescribed class of companies except OPC and small companies. So except OPCs, one person companies, and small companies, listed companies and prescribed class of companies shall appoint or reappoint an auditor. Either auditor can be individual or a firm. One term of 5 consecutive years. So one term, can auditor be appointed for 1 year? Can auditor be appointed for 3 years? No auditor can be appointed at one stretch for 5 years unless he is first auditor or he is filling up a casual vacancy. So one term of 5 consecutive years. And in case auditor is a firm, then 2 terms of 5 consecutive years. So then what happens after one term of 5 years? After one term, for in case of individual auditor, after one term of 5 consecutive years, there is a cooling period. On completion of term, one term of 5 consecutive years, 5 years from the completion of his term. So cooling period is 5 years. In case of independent directors, this cooling period is lower, but in case of auditor, cooling period is 5 years. So in case of audit firm, they can be appointed consecutively for 2 terms of 5 years each, and the cooling period on completion of the term, that is 2 terms of 5 years, consecutive 5 years, 5 years from the completion of his term. So cooling period is 5 years in both the cases. Now, this was in the context of listed companies or prescribed companies. This will not cover small companies or one-person companies. Next, specified prescribed class of companies. So what are these specified or prescribed class of companies? So we have unlisted public companies having paid up share capital of 10 crores or more. So if it is a public company, it is unlisted, but it has paid up capital of rupees 10 crore or more, then it will require to appoint auditor consecutively for 5 years and give him cooling off period of 5 years. If it is a audit firm, then 5 plus 5 consecutive years and then cooling period of 5 years. Private companies having paid up share capital of rupees 50 crores or more, it is a private company and it has paid up capital of 50 crores or more, then also this is applicable. Companies having paid up share capital of below threshold limit mentioned in A and B above, but having public borrowings from financial institutions or banks or public deposits of rupees 50 crores or more. So companies means here we are covering both public and private companies if they have public borrowings of 50 crore rupees or more. I mean, if they have borrowings, if they have public deposits in the form of borrowings, or if they have borrowings from financial institutions or banks, then if the amount is 50 crores or more, then also it will require to appoint auditor for 5 years, then give him a cooling off period of 5 years. And in case of audit firm, appoint for 5 plus 5 consecutive years and give cooling off period of 5 years. So these are the specified companies where this is applicable. Disqualification of auditors. Now, disqualification of auditors. Section 141, subsection 3. Section 141, subsection 3, disqualification of auditor. Body corporate. So auditor can be a firm, auditor can be an individual, auditor can be an LLP. But auditor cannot be body corporate except LLP. Officer or employee of the company. So officer or employee of the company cannot be auditor. Person who is a partner or who is in employment of an officer or employee of the company. So of an officer or employee of the company, his partner or his employee. If person is his partner or is his employee, officer or employee's partner or officer or employee's employee, then they cannot be auditor. A person who is or his relative or partner is holding any securities of or interest in the company or its subsidiaries or its holding or associate company or subsidiaries of such holding company, relative may hold security or interest in the company of face value of not exceeding 1 lakh rupees. So who cannot be an auditor? A person who himself is holding securities or interest in the company or its subsidiaries or of its holding or associate companies or sister concerns, that is subsidiary of such holding company, sister concerns, then auditor can is disqualified to be appointed as auditor, being relative. But if a relative of an auditor is holding securities or interest in the company only, okay, now when we are talking about relative, we are talking only about the company of face value not exceeding 1 lakh. So holding securities or interest of the face value of up to rupees 1 lakh is allowed for a relative, and only in that specific company will be checked. Otherwise, he should not have an interest in securities, then is indebted to the company or its subsidiary or holding or associate company or subsidiary of such holding company, means sister concern, in excess of 5 lakh rupees. So it has not, he auditor or his relative or partner is not in a position to pay rupees 5 lakhs or pay in excess of rupees 5 lakh. Up to 5 lakhs is allowed, but beyond 5 lakhs is not allowed. Has given a guarantee or provided any security in connection with indebtedness of any third person to the company or its subsidiary or its holding or associate company or subsidiary of such holding company in excess of rupees 1 lakh. So he has given any guarantee or provided security in connection with indebtedness of any third person, but guarantee or security is provided, and that amount up to which guarantee or security is provided is not exceeding rupees 1 crore. So in these cases, if it exceeds 1 crore guarantee security provided, then he cannot be appointed an auditor. If he himself is holding securities, then cannot be appointed as auditor. If he is indebted to the company of rupees 5 lakhs, above 5 lakhs, then he cannot be appointed as auditor. So we have to check auditor's securities, what securities he is holding in group companies of the company in which he is being appointed as auditor. So we will check securities if auditor is holding any shares or other securities. Then whether auditor is liable to pay company or its group companies any amount in excess of 5 lakh rupees, and whether auditor has provided any guarantee or warranty, guarantee or security in connection with any indebtedness of the third party to the company, and that amount exceeds 1 lakh rupees. So these all things we will check, or maybe we can obtain in writing that he auditor is not falling in these points. A person or a firm who, whether directly or indirectly, has business relationship with the company or its subsidiary or its holding or associate company or subsidiary of any such holding company or associate company. So a person or a firm who, whether directly or indirectly, has an business relationship with the company. So if a person has or firm has directly or indirectly business relation with the company or its group companies, easier term, then that person will not be appointed as auditor. Then that person will not be appointed as auditor. Here business relation shall be construed as a transaction entered into for a commercial purpose, except commercial transactions which are in the nature of professional services permitted to be rendered by an auditor or audit firm under the Act and the Chartered Accountants Act and rules or regulations made thereunder. So Business relation do not cover those commercial transactions which are allowed for the auditor to enter in professional capacity. Commercial transactions which are in the ordinary course of business of the company at arm's length basis, arm's length price, like sale of products or service to the auditor as customer by the company engaged in the business of telecommunication, airline, hospital, hotels, and such other similar businesses. So if auditor is provided some services or products of the company on arm's length basis, then those commercial transactions will not be covered. Otherwise, auditor or firm should not have any commercial transactions directly or indirectly. It should not have any business relations. Next is a person whose relative is director or is in the employment of the company as a director or key managerial personnel. So this also needs to be checked. A person whose relative is a director or is in the employment of the company as a director or KMP. So director, KMP, relative of director, not allowed. A person who is in full-time employment other elsewhere, or a person or a partner of a firm holding appointment as its auditor, if such person or partner is at the date of such appointment or reappointment holding appointment as auditor of more than 20 companies other than one person company, dormant companies, small companies, and private companies having paid up share capital less than 100 crores. So, auditor in full-time employment elsewhere not allowed, or a person or partner holding appointment as its auditor if such person or partner is at the date of such appointment or reappointment holding appointment as auditor of more than 20 companies. Key point is that a person cannot be auditor in more than 20 companies. A person cannot be an auditor if he is in whole-time employment, and a person cannot be auditor if he himself is in the employment of the company as director, as KMP. So, or a relative of a director cannot be an auditor. So these are the points, and here are exceptions for counting this limit of 20 companies in which a person can give consent and certificate that he is not disqualified to be appointed as auditor. So for the purpose of counting 20, what we will check is it is not one person company. So if he is auditor in one person company, then that will not be counted for the purpose of calculating 20 companies in which he can be auditor. Dormant companies are also not counted. Small companies, so small companies are also not counted. Therefore an auditor can be auditor in n number of small companies. And private companies having paid up share capital less than 100 crores rupees. So usually we have private companies where paid up capital is less than 100 crores. We have many. Now here we can cover many subsidiary companies, like in real estate there are many subsidiary, small subsidiary companies. So then all those subsidiaries with capital less than 100 crores, but being subsidiary they are not small companies, all those will be allowed and covered. A person who has been convicted by a court of an offense involving fraud, or a person or a period of 10 years has not elapsed from the date of such conviction. So a person convicted by the court for fraud cannot be appointed as auditor, and if he is convicted of fraud, then for next 10 years he cannot be appointed as auditor. If 10 years has lapsed since he was convicted as fraud, then he can be appointed as auditor. A person who directly or indirectly renders any service referred to in section 144 to the company or its holding company or its subsidiary company. So if he is rendering certain services as provided in section 144, like relating to maintenance of accounts, bookkeeping, so if he is providing such similar services, then he cannot be auditor of the company or its holding company or its subsidiary company. Means if he's rendering such services to the company, or rendering such services to the holding company, or rendering such services to the subsidiary, then he cannot be appointed as auditor in the company. Steps for removal of auditor, section 140. So what are the steps for removal of auditor? Number one, for the purpose of removal of auditor under section 140, a special notice is to be served. So special notice is received for removal of auditor. First, company has received a special notice for removal of auditor. The board meeting will be held. A board meeting will be held to decide about removal and then authorizing the filing of application to central government. So in the board meeting, first matter will be considered for removal, and if the decision comes that okay, auditor be removed, then an application will be made to central government for removal of auditor. Application to central government to be made in ADT 2. So for appointment or ideally for removal or casual vacancy we file ADT 1, but for application to central government form is ADT 2, and this is to be filed within 30 days of board meeting. ADT 2 is filed within 30 days of board meeting. Then we will receive approval of central government. After approval from central government, special notice to be sent for annual general meeting. So now this special notice will be sent to the members of the company. Auditor shall be given a reasonable opportunity of being heard. Auditor will be given an opportunity of being heard, and then auditor removal can be done only through special resolution. Then a special resolution will be passed and auditor be removed. Auditor will be removed. So first, company will receive a notice, special notice for removal of auditor. The matter will be placed before board, and if board decides, then an application will be made to central government within 30 days of board resolution. If central government approves, then special notice will be circulated to general meeting, annual general meeting for members approval. Members will consent, then auditor will be removed. So this is the process, and for this special resolution is passed by the members of the company. Okay, so next we move to resignation of auditor. Resignation of auditor. So resignation by auditor of government company or companies controlled by central government or state government. So in those companies, Form ADT 3 is filed for resignation of auditor within 30 days of resignation with company, registrar and controller and auditor general indicating the reasons of his resignation. So he will file Form ADT 3 of its resignation within 30 days of resignation with whom? With the registrar, with the company, with the controller and auditor general. With company, with the registrar, with the controller and auditor general. And in that resignation letter, he will disclose the reasons for his resignation. Next is in other cases, means in other than government companies, in companies in which central government or state government do not have any control. So in other companies, Form ADT 3 is filed within 30 days of resignation with the company and with the registrar. So in this case, resignation is filed only with the company and with the registrar. And that point of giving reason is also not mentioned here. Punishment under section 147. Punishment under section 147. In case a company and officer of company. So company and officer of the company, what are the punishments? Contravention of section 139 to 146. If all these provisions ranging from section 139 to 146 if these provisions are contravened, then the company is liable for a fine from rupees 25,000 to 5 lakhs. In case of officer in default, the fine will range from rupees 10,000 to rupees 1 lakh. Minimum fine is 10,000 to every officer in default, which can go up to 1 lakh rupees. And in case of company, if a company contravenes provisions of section 139 to subsection 146, then as per section 147, fine of rupees 25,000, which can range up to rupees 5 lakh, can be imposed on the company. Okay. In case of auditor, contravention by auditor under section 139, 144, 145. So if auditor makes some contravention, then if default is not willful, okay, his intention was not to commit the default, then fine is 25,000 to 5 lakh or 4 times the remuneration of the auditor, whichever is less. So it can range up to, okay, how much it can range up to. When it is saying whichever is less, means maximum it can range up to 5 lakhs. When fine is 25,000 to 5 lakh, whichever is less. And another condition is 4 times the remuneration of the auditor, whichever is less. So suppose if 4 times the remuneration of auditor comes to 4 lakhs, then 4 lakhs becomes limit. If it is 25 lakhs, then 25 lakh becomes limit. If it is whichever is less, so if it is 20,000, if 4 times of the remuneration of the auditor is, suppose it comes to 20,000, then 20,000 can be the maximum fine on auditor. And suppose if this amount increases 4 times, say it comes to 10 lakh rupees, then maximum, uh, whichever is less, suppose this is 10 lakh rupees, then whichever is less will be 25,000 to 5 lakh. So this will fall, 25,000 to 5 lakh will be taken because that is lesser than 10 lakhs. Fine. Now, if it is willful default with the intention to deceive the company or its shareholders or creditors or tax authorities. So, if it is a willful default, there is an intention to deceive the company, there is an intention to deceive shareholders, there is an intention to deceive creditors, or there is intention to deceive tax authorities, then fine is 50,000 to 25 lakh or 8 times the remuneration of auditor, whichever is less. Either 50,000 to 25,000 or 8 times remuneration, whichever is less. Imprisonment may extend to 1 year. May extend to 1 year means imprisonment can be of few hours or just one visit. If the auditor has been convicted, he shall also be liable to refund the remuneration. If the auditor is convicted, then he is liable, shall be liable to refund the remuneration. He has to refund the remuneration, pay for the damages to the company, statutory bodies, authorities, or to members or creditors of the company for loss arising out of incorrect statement in the audit report. So, if auditor is convicted, then he has to return remuneration and also pay for damages caused to the company, statutory bodies, authorities, members, creditors due to incorrect statement in audit report. So that is the implication of incorrect audit report. In case of audit of company conducted by an audit firm, so where partners of audit firm has or have acted in a fraudulent manner, abated or colluded for any fraud by or in relation to or by the company or director or officer, in relation to or by the company or its directors or its officers. So here firm is involved and partners of that firm who abetted, colluded in fraudulent manner. The liability, whether civil or criminal, under this act or in any other law in force for such act shall be of the partners concerned, of the audit firm, of the firm jointly and severally. So both are covered. In case of criminal liability, this was in case of civil liability. Now, in case of criminal liability, something additional will happen. This will happen in civil or criminal, what we have already gone through. In case of criminal liability of the audit firm in respect of liability other than fine, the concerned partners who acted in a fraudulent manner, abated as the case may be, colluded with the fraud, shall only be liable. So, in case of criminal liability, then concerned partner shall only be liable, but in case of generally in otherwise, firm and partners both are liable. Okay. So therefore, considering liability, auditor has to be careful, very careful. So let's conclude here. Next, we will start with appointment and qualification of directors. Disclaimer that this is only for revision purpose. Thank you.